Hello everyone, this is Jim Parrish and I want to welcome you to our YouTube channel. I'm going to talk to you a bit today about trucking accidents. Chances are you or someone you know knows someone that's been involved in an accident with a tractor trailer or some other kind of commercial vehicle. These accidents, and I'm hesitant to even call them accidents, they're preventable collisions in reality. But they're far too common today, and they result typically in catastrophic results, ruining people's lives and tearing families apart. If you or someone that you love has been involved in a collision with a tractor trailer or some other kind of large commercial vehicle, the first thing you need to do, of course, is to seek medical assistance for any injuries. You need to call the authorities as well. The state police and other local authorities have special units that come to the scenes of these crashes because investigation of them requires training far beyond that related to a normal automobile accident. Also, it's very important to contact a lawyer with skills, knowledge, and experience in the trucking and commercial collision world. There are special steps that need to be taken by your attorney, and they need to happen quickly. It is extremely important to preserve evidence of the collision and also determine all of the players involved. In order to hold someone responsible for a tractor trailer or large commercial vehicle crash, you must demonstrate that the driver of that vehicle was negligent. In trucking cases, we also look at many other entities that may be involved and may have liability or responsibility for the crash. Those other parties include the trucking company itself, also the broker that scheduled and set up the trip between the shipper and the trucking company. There may also be what's known as a products liability case, such as in a tire blowout. If you or someone you love has been involved in one of these horrible crashes, you can contact the Parrish Law Firm 24 hours a day. We have live operators ready to take your call, and they will email me or contact me personally to discuss your case, and then I will get in touch with you or your family very soon thereafter. It may be that we need to involve a crash reconstruction team. I know several of these organizations throughout the United States, and they will fly in, drive in, whatever it takes to get to that scene, preserve the evidence, and start building the case that you need. In Virginia, if you are injured due to the negligence of another person, you are entitled to recover for your medical bills, and that means all of your medical bills. There is no offset or credit for use of health insurance, and by the way, you should always use your health insurance even if you're involved in one of these collisions. Your health insurance will pay the bills, and chances are you won't have to pay the health insurance company back. In Virginia, you're also entitled to recover for your lost time from work. This is known as a lost wage claim. And again, just like with health insurance, even if you have sick leave, vacation, or disability pay, you can still claim the full amount of time that you're out of work. So for example, if you make $75,000 per year and you miss a full year of work, you can recover that full $75,000 even if you use sick leave or vacation pay or had a disability policy through your company that gave you money throughout that period of convalescence and while you were healing. In Virginia, you're also entitled to recover for your pain and suffering, and that means mental and physical. You're entitled to recover for your inconvenience. Your inconvenience is not something that you can plug into an equation, but rather it's demonstrated by a number of things. For example, if you're not able to attend an important family event because you are injured, that's an inconvenience, and that's a large inconvenience. I've had clients in the past that have actually had to miss close family members' weddings. Another example of inconvenience is it makes you do things you don't want to do. You have to spend your time going to the doctor, you have to spend your time going to the physical therapist. You don't want to do those things. You want to be living your normal life. But you have to do things you don't want to do, and then you can't do the things you do want to do, such as attending family events, such as if you're a member of a sports team and you're playing on the weekends, and that brings you great enjoyment. You're not able to do those things. And believe it or not, part of inconvenience is missing work. People want to work. They want to be at their jobs. They want to be contributing. But when they're injured and they're unable to do so, that is another substantial inconvenience. In Virginia, if you have a permanent injury, you are entitled to recover for that permanent injury for the remainder of your life. So if you're 30 years old when you're hurt, and the Virginia life expectancy table indicates that you should live until you're 83, we're going to claim 53 years of continued pain and suffering, disability, and limitation. In Virginia, you're also entitled to recover for what's known as a reduced earning capacity, and that happens frequently in these types of trucking cases. For example, if I'm a plumber and then my hands are hurt in the collision and I'm no longer able to do the work of a plumber, but I'm still able to work in the office, we're entitled to capture the difference between those two earning jobs. For example, if you made $100,000 a year as a plumber, but then became unable to work as a plumber because of your injuries, and you had to work in the office making $50,000 a year, we're going to capture and claim and help you recover that $50,000 difference per year for the remainder of your work life. Another thing that we see in these types of cases, because the injuries are so bad, is scarring, and the law uses the term scarring, disfigurement, and deformity. I've represented people that have lost fingers and other body parts, and of course these are horrible, horrible events, but the law does allow you to recover for those items. One of the most unfortunate things about Virginia law is that we still follow the antiquated principle of contributory negligence. And what this means is that even if you prove the truck driver or the trucking company or the broker or the shipper were negligent, then they can point the finger back at you or the driver of your vehicle and try to claim that you were also partially at fault. This is known as contributory negligence, and if a jury finds that you are 1% at fault for the collision, Virginia law says you get nothing. It's extremely harsh. Most states use what's known as comparative negligence. Comparative negligence does just as the terms describe, and it compares the two behaviors and actions of the people involved. For example, if the trucking driver was 90% negligent and you as the victim were 10%, then you would get a jury verdict of, for example, $100,000, and it would be reduced by your portion of comparative negligence. So in this case, by 10%, but you would still recover $90,000 of the $100,000 verdict. In Virginia, you would get zero. Again, that's very harsh. This goes back to the reason that you need to get a lawyer involved as soon as possible after one of these horrible preventable crashes, so that your attorney can advocate for you with the insurance company or risk management company that's going to be representing the trucking company, the truck driver, the shipper, or the broker. I hope that the information that I've given you today has been helpful. I truly hope that you never have to call me. But if you or someone you know has been involved in a motor vehicle collision and been injured involving a tractor trailer or some other form of large commercial vehicle, we at the Parrish Law Firm are here to help. You can contact us via phone, via our website. You can text us. If you contact us, we will do our best to help.